us do have everybody. I can't get a view of everyone on my little telephone screen, so I can't necessarily tell when everyone has joined. Okay, Mr. Riley, I see you, and you are up.
Thank you, Your Honor. May it please the court. I am Patrick Riley, and I represent Ellen Jones, the appellant, in her capacity as the personal representative of the estate of Loretta Thomas. I'd like to reserve 3 minutes for rebuttal.
Sure.
The probate court in Charlotte County permitted a judgment creditor to execute upon real estate owned by the Thomas estate, which is the only asset that was owned by the Thomas estate, thereby depriving the personal representative of the ability to administer the estate. We contend that the judgment was nothing more than a Class 8 obligation under the probate code, and therefore it should not receive any special priority over any of the other debts and obligations of the estate. Additionally, the probate court made its decision based on principles of equity, and in doing so relied upon matters which were outside of the record. And we believe that this issue should have been governed by the probate code and not by those issues. Ellen Jones was appointed as the personal representative of the Thomas estate in 2006. Adelaide Tennell filed a claim, or actually her guardian filed a claim against the Thomas estate, which was objected to, and ultimately there was a civil claim that was filed. The matter went to trial, and on February 3rd of 2020, a judgment was entered in favor of Adelaide Tennell and against the Thomas estate in the amount of $2.2 million. Subsequently, Adelaide Tennell passed away, and Attorney Lance McKinney was appointed curator of her estate. After that occurred, there was an agreement of sale for the real estate that was entered into between the estate of Loretta Thomas and a third party. The problem was that because of the judgment, the closing agent told Ellen Jones that upon closing, the money was going to be presented to the Tennell estate because of the judgment. As a result of that, we filed an emergency motion with the court asking for permission to sell the real estate. We argued that Attorney McKinney and the estate did not have court approval to execute or levy on the property. Therefore, it would be inappropriate to turn the money over to the estate. And that additionally, if the money were not turned over to the estate, it would interfere with the ability of the Thomas estate to administer the estate. There was a hearing held, on September 14, McKinney also filed a motion for issuance of writ of execution after we filed our motion asking for court approval. And subsequently, on the 16th, he filed a motion for judicial notice with regard to the February 3rd, 2020 judgment, which was finally properly recorded on September 16 of 2020. Hearing was held on September 17, and the probate court said that the Thomas estate could sell the real estate. The money would be dispersed to the estate and could be utilized to pay the costs and expenses of the estate. If the order had stopped there, we wouldn't be here today. Unfortunately, the court muddied the waters by putting a footnote to its order that said, this court notes that the decision issued today does not affect the validity or invalidity of any lien placed on the subject property. Settlement occurred on September 23rd of 2020. The funds were provided by the bank and wired to the title insurance company. Settlement documents were signed by the buyer. The buyer was awaiting news that everything had gone through, and the closing agent received a letter from McKinney stating that if Ellen Jones, as the personal representative, were to execute a seller's affidavit indicating that there were no liens on the property, she would be committing perjury. No surprise, the title insurance company refused to issue title insurance and the settlement fell through. After that, on September 25th, we filed an emergency motion with the court, not a motion for rehearing, but an emergency motion with the court asking the court to enforce its order of September 17, allow the sale to go through and the proceeds to go to the Thomas estate, free of the lien. On October 2nd,
the court had never ruled that in the first go round, the court did not rule that the property was free of the lien. In fact, it said just the opposite, correct?
It said it was taking no position with regard to whether it was a valid or invalid lien. It didn't rule. That's correct. On October 2nd of 2020, there was a hearing, and it's important to note that at that time, McKinney presented no evidence on behalf of the Tennell estate. The court noted during the hearing that enforcement of the Tennell estate lien or allowing the status quo to remain would interfere with the proper administration of the estate. The obvious conclusion is that if the Thomas estate were permitted to sell the property and the proceeds were deposited into an estate account, there would be no interference with estate administration. So the probate court clearly understood, based on its opinion, that it had to consider what the effect was on the administration of the estate. It's important to note that nowhere within the record is there anything regarding the underlying civil case which led to the judgment, except—
Well, that's not quite true. I mean, the judgment is characterized throughout the record as being for theft or abuse of the elderly and that sort of thing. I mean, you're about to get to, well, they bought the defendant in that case bought the property with the proceeds, and I think judge may have waxed too poetical writing that judgment, but that order. But the fact of the matter is that the record, wholly aside from that, reflects that that Loretta Thomas stole from Adelaide Tunnel or Tunnel, I don't know what her name is, how to pronounce it, but and that's it. Stole a lot.
Well, Your Honor, I said except that the judgment does state that.
But your argument that the judge went outside the record is really, neither here nor there, I think, given that the theft is apparent on the record in this case.
I would disagree with the court for this reason. The court, in rendering its decision on October 8th, said that to understand the dynamics of the case, one must venture back in time to the institution of the civil action, and that led to the judgment. And then the court went on to say, which I think is important, the verdict of the jury and issuance of the judgment after trial clearly show that the subject property was purchased and paid for with ill-gotten gains. There is nothing within the
and you know what, and whether that's in the record or not, the McKinney here wasn't seeking to enforce any sort of equitable lien, correct? McKinney's is attempting to enforce a judgment lien that's furnished as a matter of law.
Correct.
So even though the judge recited those facts, the fact that there was a theft was on the record, and the fact that the jury granted a judgment on that basis is in the record, and what's being enforced here is a legal lien, not an equitable one, correct?
I would agree, Your Honor, except that the court indicated its decision was based on equitable principles.
Well, and the court felt that there were two, as it viewed them, two competing interests, and for maybe in the court's mind it would have been a toss-up legally, and came down on the side of equity. But I don't think that one assertion of fact taints the whole judgment. It taints the legal issue that's in front of us.
Well, the only reason I pointed out, Your Honor, is that the court's equitable determination is based entirely upon the underlying civil action and what—
right. And what I'm pointing out to you, I think, is that the equity is there regardless of the observation that the property was purchased with the proceeds of the theft, because this is not an equitable lien. Correct.
Correct. So what we have is that the court recognized that it would interfere with the administration of the estate, but ignored that. In the first instance, we would contend that the probate court should not have permitted the levy because it interfered with the administration of the estate. And here's something important to consider. Had the house been sold prior to the time the judgment was properly recorded, there would be cash in a bank account. There would have been no way for the Tunnel estate to have attached that. It would have been simply a Class 8 creditor, as would any other judgment that did not have any kind of lien. As the court noted, it was fortuitous in this particular instance that the house had not been sold and had not been converted to cash, which to me would be a clear signal to someone in the future. If you're filing a claim against the estate and it's at all possible, file a lis pendens against that estate so that property can't be sold until there's a judgment. And so then if this decision stands, then the monies would go to the judgment creditor as opposed to being paid.
I'm not sure I agree with that, because your typical judgment creditor who has no relationship to the decedent, as occurred in this case, based on the civil theft judgment, I'm not sure they might have a problem with putting a lease pendens on property that is unrelated in any way to them. Here, to go back to Judge Northcutt's question or observation, you have a legal lien, and then for purposes of probate, the court can take into account equitable considerations as to how to handle the probate and how to address the lien. So I'm not sure your suggestion that any judgment creditor would be in the same posture as this particular judgment creditor.
No, and I wasn't suggesting that either. What I said was in an appropriate instance, someone could file lis pendens and therefore keep the property in kind so that it's not converted, so that they could then assert a lien against that property later on.
Well, and here didn't the trial judge essentially have to weigh some competing interests? You know, one is, we know what the probate code says. Two, we have a judgment creditor who has obtained a judgment specifically finding that there was civil theft. So isn't that exactly why the court has some equitable discretion to exercise?
I would agree, but what that does in this instance is it takes away any possibility of the estate to be administered, any possibility of the personal representative involved representing the estate getting compensation, any possibility of counsel who were involved, as in this instance, for 5 years administering the estate and defending the litigation, even though the legislature said those obligations are class 1 obligations. Under these circumstances, they're not going to be paid.
Well, yeah, but you know, also the judge was weighing against that the fact that if your argument is correct, and I'm not sure that it is, as a matter of law, then it takes away any opportunity for this victim of this intentional tort to recover on her judgment, or her heirs to recover on the judgment. I mean, those were the two things the court was weighing in terms of what the equities were.
Well,
but getting to the Class 8 issue, why isn't this judgment lien just enforceable outside of the you know, as a lien enforceable outside of the priority list, just like a mortgage is?
It's not like a mortgage, because under section 733-706, a mortgage, a security interest, and a lien in a specific piece of property don't require court approval for sale. In this instance, because it's a general lien under section 5510, the court approval was required in order for execution and levy on.
Okay. And then why couldn't the judge grant the permission?
Well, because the statute clearly 733-707-1 sets forth the priority of creditors in this particular instance. And if you look back at 706, where the court has the authority to authorize an execution when it's applied for, well, what guidelines are there for the court to determine whether or not that execution and levy ought to be permitted? The guidelines have come through statutory history that's over 100. I'm sorry.
No, you're talking through case law. You keep calling it statutory interpretation, but you're not interpreting any words in the statute. You're pointing at case law that says it shouldn't interfere with the administration of the state.
Yes, Your Honor. What I'm saying is, if you look at 706, there is no statutory guidance for what the court should consider in determining whether or not to permit that execution or levy. But for 140 years, Florida has said that anything that interferes with the administration of an estate is not going to be permitted. That goes back to the Post versus Love case of, I believe, 1883. And then in 1942, the Florida Supreme Court decided the Brown versus Sweat case.
Well, Mr. Riley, to correct your response a little bit, and I'm only jumping in because this is statutory, but 733-706 says claims on all judgments against a decedent shall be filed in the same manner as other claims against estates of decedents. So there is a directive from the legislature that you get a judgment, you're supposed to file it in the same manner as other claims, which would presumably include 733.707.
Right, and the stated reason for that is, according to case law interpretation, that the judgment is not given any greater or any special status other than any other claim that's made against the
Well,
estate.
and that, that may be true, but we are talking about a judgment. This isn't just any judgment, and the judgment creditor is seeking to collect from the estate generally. This is a lien on property. So it seems to me that one way, and one way that this can be interpreted, the priority can be interpreted, is this is payable as a lien against the property of the real estate in the estate, and we know that this judgment is for $2 million plus, and that the property is worth under $600,000. We know it's not going to be enough. That property is not going to be enough to pay off the judgment. Seems to me the balance of that judgment is an unsecured, no lien, and it's a class 8. The balance of the judgment beyond the lien. Isn't that one way to look at the statutory scheme?
That's one way of looking at it, I suppose. Your Honor would have to admit that, but I don't know that anywhere there's any support for that particular interpretation.
Well, but I don't know that there's support that says they don't get to enforce their lien under 55.10.
Well, I would agree, except that again, if you look at the cases interpreting whether or not execution is permitted, including in 2003 in Murray versus Nations Bank of Florida, the court permitted an execution against estate property, but only because the probate court had found that it would not interfere with the administration of the estate. In this case, the probate court acknowledged it was going to interfere with the administration of the estate. The other thing I take issue with in the court's opinion is the court says that the judgment creditor is likely not to get anything, any money out of the estate under these circumstances. Well, as you indicated, the property was under an agreement of sale to sell for, I believe, $575,000. If the court is suggesting that there's $575,000 in claims for the estate attorneys and for the personal representative, I don't know where that information came from. The record has shown that there will be sufficient funds, or there will be some funds available to satisfy the estate under these circumstances, albeit all of it wouldn't go if the court were would permit the sale and the money to go to the Thomas estate.
And Mr. Riley, you're down to 3 minutes for use them as you wish.
Thank you, Your Honor. In conclusion, it's our position that the trial court made an error here, and then under the probate code, the court was required to permit the funds to be provided to the Thomas estate for the administration of the estate to occur, and then whatever was left to go to Class 8 creditor, in this case, the Tennell estate. Thank you.
Okay. Thank you. All right, Ms. Haverfield, it's your turn.
Thank you. Good morning. My name is Stacy Haverfield. I represent appellee Lance McKinney as the curator for the estate of Adelaide Tennell. We respectfully submit that the notice of appeal was untimely filed and request that this court dismiss it as a lack of jurisdiction. Alternatively, we submit that the trial court got it right. The trial court's interpretation, weighing the different statutes, applying the ordinary and plain meaning of the language in all of the statutes, reached the right conclusion, which
Okay,
is—
on your first point on the jurisdictional issue, let me ask you a question. I mean, I've looked at the order, and I've looked at the motion that what your side says is a motion for rehearing, and they say it was a motion to enforce. And I acknowledge, I think you could read it one way or the other, and if we can read the motion one way or the other, what is our obligation?
are you asking in equity?
Or just in terms of our jurisdiction, should we weigh in favor of finding jurisdiction if we can read the motion two different ways?
I would still suggest that you should weigh in favor of dismissing.
Okay. So why?
Okay.
And then I have another related question.
Okay. Yeah.
Go ahead.
Well, so I think the statutes regarding, I'm sorry, the rule regarding jurisdiction and the timeliness for filing a notice of appeal is jurisdictional. I mean, it's a hard and fast deadline in civil, and one misses the deadline, that's it. And this was not an issue of folks didn't think that the dissolution of the lien wasn't discussed, or I guess more specifically as it relates to the September 17 order, that the validity of the lien was ever called into question. No one was doubting that was not argued, it was not put forward, because everyone just moved forward as though it was valid. And so by not filing the notice of appeal from the October 8 order, the appellants are late. That's, it's jurisdictional. That's my argument. I mean, these rules are in place for a reason, and we're charged with the responsibility of filing the rules. And the notice of appeal was filed more than 73 days after the deadline.
All right, let me come back then to that scenario. Okay, the October 8th order, did it, and was it, what was the date of the prior order? September
17.
Okay, the October 8th order, did it alter what was ordered in the September 17th order in any way? And if so, would that give a party another right to file a motion for a hearing from the October 8th order?
Yeah, admittedly, I went round and round on that.
Yeah, I mean, I get.
Yeah, I mean that's an interesting scenario. 1, 2. So let's look at the September 17 order and exactly what it did.
Cool. One thing the October 8th order did was withdraw permission of the personal representative to sell the property, correct?
Right. Correct. Correct. And frankly, yeah, by my read, that's the only thing that the October 8 order did. So the September 17 order really didn't change anything. Appellant Jones went to the court and requested basically a removal of the lien because she caught wind of the fact that the title company was not going to allow the proceeds to be issued to the estate. And so even though she had the authority to sell per the will, she went to the court and asked the court to remove that lien. What the court did was say, okay, Appellant Jones, you may sell. Right, you may sell. And so therefore, Appellee McKinney, I'm not going to grant your motion because I don't need two of you trying to sell one piece of property, but the lien is going to remain here. Now press on. And unfortunately, that created a stalemate, which then necessitated this second motion. But this second motion was not a motion to enforce. No one was trying to enforce that September 17 order. Rather, what they wanted the court to do was remove that lien.
Well, they were frustrated that the sale couldn't go through because the lien was there in the court.
Correct. So when it boiled down, the October 8 order changed who had the obligation or the authority to sell the property. The lien remained in place. The acknowledgement that the lien was secured by that property and that the Appellee McKinney was going to receive the net proceeds from the sale, all that remained the same. The only thing that changed was who was going to bear the burden of actually selling the property. And again, the jurisdictional deadline is hard and fast. And so that would be our argument as to why this appeal should be dismissed as untimely.
Okay.
Moving on.
We've chewed on this once. The court has chewed on this once before, and I think we'll have to keep chewing on it. But can we go to now the underlying merits? Why wasn't this a Class 8?
It is. Yeah, it isn't a Class 8. It isn't a Class 8 for the one very significant reason that it isn't just a judgment. So yes, it started out as a final money judgment back in February 2020, but when Appellee McKinney followed the steps as set forth in 5510(1), he elevated that to perfecting a non-mortgage lien, which attaches to the property. And the probate code and the specific statutes that were cited, for example, it was 733, 706, 733, 702. These statutes talk about how the probate code is not for the purpose of not paying creditors, and importantly, it's not for the purpose of impeding those who are lien holders, mortgage holders, security interest holders from being able to collect on property. And even in
But you would concede a judgment lien is categorically distinct from a lien on specific property, correct?
I would agree.
Which is
that-
what the statute speaks in terms of those lien priorities. That's why the mortgage company gets to jump ahead of everybody, because they have a specific lien on this specific property that has to get taken care of before there's anything to even talk about.
Well, let's take that a step further, though, because that particular statute section has 5 sentences.
Mhm.
And so the 5th sentence is what you're referring to, I believe, where, it says that, and I'm paraphrasing now, nothing in this particular statute section that requires a judgment creditor to come forward and ask in the probate court for an application for an execution or levy. That last sentence then further clarifies, now look, we're not going to get in the way of mortgage holders, security interest holders, and lien holders against specific property. But what it doesn't write or read is that any other lien holder, even as to general property, may not make application to the probate court and may not receive.
Fine. I'll go with that.
And let me,
I'm sorry.
and
go
in
ahead,
that
Judge
regard, let me point out that, and I'm kind of wondering, the statute talks about, I'm trying to pull it up. So, statute says mortgages, security interests, and lien against specific property. Okay, well, we know that a lien against specific property is something other than a mortgage.
Correct.
Is it something other than a security interest?
Well, security interest is defined in the definitions as.
It could be a construction lien, mechanics lien, something like that.
Okay. And so then what is a lien against specific property in the real world? If this is not, what is? That's
Well,
what I get.
there's a giant discussion on whether or not this is a specific lien or a general lien. This lien actually is specific as to certain things. It's a lien
As
specifically
to
against
property,
real
as to
property
real property in the county in which it's
in Charlotte County.
in which
Got
it's
it,
recorded.
yes. So to that extent, it is a lien that attaches to and secured by.
It's a
specific
lien that
property.
attaches to any real property she has within Charlotte County, but that's not specific property. I mean, there's hundreds of thousands of parcels of real property that she could potentially own in Charlotte County. It's just happenstance that this is the one she owns and the one that we're talking about. That doesn't change it into a lien on specific property.
That's fair enough, Judge Lucas. And I think,
I think that begs the question. I mean, what is a lien on specific property other than this? I mean, that's begging the question.
I think it
We
would
know
be an
mortgages are taken care of. We know security
Right.
interests are taken care of. What's a lien?
I
on
think the
specific-
answer to that would be like a construction lien that's, your contractor comes out, does work on a specific piece of property that's identified, ends up filing a claim of lien, and it specifies the property that they're going after. I mean, that would be how one could read it. My concern, I just kind of cut to the chase on this, is that I hear what you're saying about, look, 733.706 has this kind of, it starts with except upon approval of the court, which kind of intuits that there's some kind of approval of court that could be given. My concern, though, is that whatever that provides could not thwart what the legislature then goes on and classifies as how these payments are supposed to be, and judgments fall within Class 8. Whether or not there's a lien that you can then, the fact that there's a lien on real property just means that there's a lien on real property. It doesn't change that this is a presentation of a claim on a judgment. And so you all have effectively upended the order that the legislature has set up. You've gone from Class 8, the bottom, to basically ahead of Class 1, the top, and there's no fraud exception that's baked into this classification scheme. Unlike in bankruptcy, where you commit a fraud in bankruptcy, you get found civilly liable in bankruptcy court, you're not going to get that discharged at all. That's not here in this, and that's what's troubling to me. So help me out within the statutory framework why I shouldn't be concerned about that.
Sure, thank you. Well, so you should not be concerned about it for a few reasons. First, if we take the probate code as a whole, the word lien, not associated with specific lien, but the word lien is mentioned periodically throughout the probate code. And in the probate code then further reads, and I'm paraphrasing, but something along the lines of, the probate code is not intended to not pay valid creditors, and then sort of especially this group of potential creditors, right? Mortgage holders, security interest holders, and lien holders. That's us. We're the lien holders. And so by forcing our perfected non-mortgage judgment lien that we all acknowledge has attached to the property and is secured by this property to then receive a Class 8 treatment ignores 5510. So
Ms. Haverfield, let me ask a question relating to Class 8 creditors under 733-707. Class 8 creditors are all other claims, including those founded on judgments or decrees rendered against the decedent during the decedent's lifetime. So someone who sues and gets a judgment, which is reduced to a final judgment recorded in the public records and which constitutes a lien on any property owned by the decedent, that is a Class 8 claim. And so now what we're talking about is a claim that was rendered after the decedent died and is reduced to judgment. Why would the statutory scheme, the way you're analyzing it, give a higher precedence to a claim rendered against the decedent after the decedent has passed away, as opposed to someone who got a judgment before the decedent passed away, which would act in the very same manner on real property?
Oh, okay. So you and I have a fundamental difference of opinion.
Well, maybe not. Maybe not.
Okay.
Don't make an assumption, but you know, that's
Okay.
what the statute says. So, you know, as Judge Lucas pointed out, help me understand why a judgment that's obtained after the decedent is gone is now going to jump over the precedence of claims on judgments that were rendered while the decedent was alive.
Sure. See, my read of the statute, my read of 733-707, the timing is not relevant. So under your fact pattern, had Apolli Tennell received her judgment pre-2016 when Mrs. Thomas passed away, and then still followed the steps as set forth in 5510, she would still be a secured creditor, or Apolli McKinney would still be a secured creditor and would not be subject to this order of payment of expenses and obligations, which I read to be unsecured. So these are, things like funeral bills, medical bills, child support. These are not liens against property, or more specifically, secured debts. And so
And mortgages are not listed in that priority scheme, correct?
correct, yes.
So really we need to go to the section that says this limitation or whatever does not apply to mortgages, security interests, or
liens.
proper secured liens on specific property.
Right.
Because otherwise, how does a mortgage get paid?
Right.
Oh, we know it's not part of that priority list.
Right. Yes. And so now you're addressing the language in 733. I think it's 402. And forgive me because I don't
I'm
have
having
it.
trouble. My internet is out on my computer, so I can't get it. I can't download it. I've got it, but I can't download it.
And I'm not sure I got a satisfactory answer, Ms. Haverfield.
Oh, I'm
Because
sorry.
if a creditor gets a judgment against a decedent before the decedent dies, so against a person before death, unless I am mistaken and the law has changed since I've been on the court, just about every creditor records those judgments so that they can pursue execution and levy on any property. So your position seems to be, as long as they follow the requirements of Chapter 55, they are no longer, will never be a Class 8 creditor. They are now a secured creditor that jumps to the head of the class and takes any property that's out there outside of the administration of the estate. Am I understanding that's your position?
Yes, that is our position. And I would add a few details to that. I mean, if we read section 733-706 as Judge Lucas presented, where there has to be an application made to the probate court for execution, so then you still have that issue. So execution can't just randomly take place or willy-nilly take place, even though the judgment creditor would not necessarily be subject to this order of priority of payment of expenses and obligations. There is still an obligation on the judgment creditor then to make application to the probate court and seek execution if it is post-death. Now, as you point out, if it's pre-death, then certainly, we follow 5510, and then execution opportunities and procedures then play out.
So all real
I come back to the difference between that portion of the judgment that is secured by real estate and then the portion of the judgment that is in excess of the value of the real estate. So if you have the lien on the real estate, you may or may not, and that's kind of what we're arguing about today, be outside of the to the extent there's a lien on the real estate, it's outside of the priority list. But to the extent there is and it doesn't say judgment, it says claim based on a judgment is a category 8. And so I think certainly the value of the judgment that's in excess of any lienable property is a claim based on a judgment. Correct.
Correct.
Certainly that would be a category 8.
Yes. Well, and so that leads me to one other point that I wanted to address quickly. The unfortunate reality in this particular estate administration is it is insolvent, period. There's not going to be enough to pay everybody. And the reason I know that is because Applee McKinney holds a $2.2 million judgment. And
Ms. Haverfield, that's true whenever, to some extent, that's going to be true and inherent whenever you classify claims and debts, that there are people that's why legislatures classify them, is because it's presumed there's going to be estates where there's just not enough money to go around to everybody. And so the legislature puts a priority in order. Why should this be different when it's not specified, when fraud judgments or civil theft judgments, maybe they should be, but they've not been specially categorized?
Well, respectfully, I think they have been categorized under the execution and levy, which then it doesn't say any and all other lien holders have to wait in line in Class 8. That's not what 733-706 reads. It simply reads in sentence 5 that, look, this section is not meant to thwart or prohibit those who have mortgages, security interests, and liens on specific property from actually executing to collect on the judgment. It does not prohibit us from falling under this statute section, which Applee McKinney properly did, seeking approval from the probate court, which then leads me to another point that was made that I want to address quickly. We're at a stalemate. So the estate of Jones and the estate of Tennell are at a stalemate, and the trial court properly recognized that. In allowing Applee McKinney to execute on this judgment, he removed that stalemate. And so this idea that the estates are not going to be able to be administered orderly is a no-starter. Really what's being said here is, unfortunately, everyone's not going to get paid. And we recognize that, and that's unfortunate. But that doesn't mean that the estate cannot then close down. In fact, by maintaining the status quo, which is actually what the trial judge wrote in his October 8 order, by maintaining the status quo and having the personal representative have the authority to sell, but then still keeping the lien on the property, these two estates are going to remain open forever because we still have an asset that needs.
And then I'm gonna recharacterize what you just said as I took it in, but then your time is up. So as I see it, being unable to administer the state does not mean not being able to pay the top priority in the eight category list of priorities. It seems to me that the other side has argued, it interferes with the administration of the state because we can't pay category 1. But neither can you ever pay category 8, theoretically. That's not an interference with the administration of the estate, that you can't pay a particular category.
Correct.
All right. So your time is up.
Okay.
And I'm I'm sure your opponent might have a comment to make on that. But anyway, so Mr. Riley, you are
Yes, thank
up for 3 minutes.
Thank you, Judge
Mr.
Northcutt.
Riley, one of the things I'd like you to address, and we started talking about this in your initial argument, the first portion of 733-706 says, except upon approval by the court, no execution or other process shall issue on or be levied against property of the estate. And so it seems to me that what Ms. Haverfield's client is arguing is that they should in fact be allowed to execute or levy against the property that would otherwise be part of the estate, but for the judgment. And so then do we get into the equitable discretion of the court, which is except upon approval by the court?
Well, I think it's self-evident from the statute. There has to be court approval under the circumstances like this, where there's no mortgage, security interest, or lien specific to the
But
property.
there is a judgment that is executable and could levy on property. So why is the court not permitted to take into account the nature of the underlying judgment?
Well, the court did take into account the nature of the
It did.
underlying judgment.
It did,
I'm not
and it said this property is going to proceed with levy or execution because of the circumstances giving rise to the judgment.
Right. What I'm suggesting is that the interpretation of the statute says it can't interfere with administration of the estate. I want to go back to a question Judge Northcutt asked, and counsel stated that the court decided that this estates were in a stalemate because of this situation, and she suggested that by allowing the execution to move forward, that relieves the stalemate. But that's not the only option for relieving the stalemate. The court could have determined that the Thomas estate had authority to sell it and to put the proceeds into the estate and then administer probate accordingly. There is no one who's going to be willing, if this decision stands, who's going to be willing to move forward to close this estate? If this decision stands, who in the future under similar circumstances is going to be willing to serve as a personal representative or counsel? Because as Judge Lucas noted, if this decision stands, it does turn section 707(1) upside down. And so it's and going back to the issue of the lien itself is a general lien. The court in the Patashall, Smith versus Patashall case, which I cited in my brief, says the general lien created by section 5510 doesn't create an estate or right of property in the debtor's land. It creates a lien upon the land to the exclusion of adverse interests subsequent to the judgment. That's all it does. So this judgment should not be given any greater status than any other judgment that there may have been against the Thomas estate, simply by virtue of the fact that there was a piece of real estate as opposed to cash sitting in a bank account. The court noted it was fortuitous that it was that way. And so it's our position that the court's decision is wrong. It should be overturned. And in the interests of the administration of the estate, the money should go to the estate and be distributed. And the Tennell case will receive whatever is left over after the first 7 classes of creditors get their payment.
Okay, thank you very much. Thank you both. This is
Thank you.
interesting case. So in order to leave our virtual courtroom, you click